We've got to talk about. See, here's the thing. I'm going to do a little preamble here. At our live show, the Breakdowns live show in Edmonton, for those of you who were there, this part didn't make it into the audio recording, unfortunately, because we had some technical issues. But there was a moment where one of our audience members was very fired up, very passionate, appreciate it, respect it, loved it. He was very upset. He's a member of a couple of different communities that are being punched down on by the UCP, no question. And I had used the word in that program, authoritarian, to describe the current provincial government. And this gentleman was expressing some frustration that the other panel members had not used the similar vernacular to describe what was going on in the province. And he got pretty fired up. He was advocating for some strong things. It was a spirited discussion. And again, one that I'm very, very, very grateful for. My response to that young man was, I'm saying that because I'm very, very old, not because he was super young. I've spent a week having people point out that I'm old. So we'll call him a young man. My response to that young man was like, look, I get that the UCP is passing a bunch of horrifying laws. We're talking about the book bans in particular at that night. I get that the UCP is passing a lot of laws that are definitely authoritarian. They're definitely a little fashy. But we still have the courts. As long as we have the courts, there is a process, and that process matters. And I 100% believe that. I still do. I'm a little worried, though. And the reason why I'm worried is because there is no question that the UCP, Danielle Smith in particular, are doing everything in their power to delegitimize the courts, as well as to gain greater control over the courts, which are supposed to be arm's length and objective. I don't need to tell you that, though, because there's going to be some people who talk with much more authority than I can coming up in just a minute here. But we got to talk about the timeline here, because it's really important to contextualize. First of all, Danielle Smith rolls out her anti-trans laws. She rolls out her book bans. She rolls out bunch of other laws that people go, oh, we're going to challenge that in the courts. We are, particularly the anti-trans laws. And there was an injunction that was put into place by a judge who said that if Danielle Smith's anti-trans laws were allowed to go ahead, they would cause real and permanent harm. And that pending the outcome of the court situation, those laws were not in effect. They could not be in effect because they were going to cause real and permanent harm. Now, these are some of the laws that Danielle Smith ultimately used the notwithstanding clause for. But we got to go all the way back to December of last year for this particular timeline exercise that we're going to do tonight. Because it is in December of last year that we started to really see the ratcheting up of the language of Danielle Smith attacking the courts and attacking judges.
I'm going to try to boil it down to the significant question, and it does relate to the repeated use of what he says, the Constitution's nuclear option to circumvent the courts and override the will of Albertans without legislative debate. He is talking about, of course, the charter challenge.
Well, those are two different things. The will of Albertans is not expressed by a single judge appointed by Justin Trudeau and never faces any kind of recall campaign, never faces any kind of election. That's what we're talking about, is that in a lot of these cases, the people have told us through our consultation, through our elections, the kind of things they want us to do. And then we go and do them. and then the court can override it. And the court, again, most of the judges are appointed by Ottawa, not by us. And why should? I mean, I think that's it is not synonymous to have an unelected judge. An unelected judge is not synonymous with democracy. Democracy is when elected individuals who have to face the electorate every 4 years make decisions. That's what democracy is. So I think that things are getting a little bit muddled. They're getting. We believe that in the actions that we have taken, particularly when it comes to protecting kids' right to be able to have kids of their own one day, so that they do not make premature decisions to affect their fertility. We believe that girls and women have a right to participate in sport without having to compete against born male athletes. And we believe that parents should have a right to know what's going on with their kids at school. Those are very strong, strongly supported policies, well above 70% of Albertans. So we believe we're the ones being democratic. The court stepped in and wanted to put an injunction on one of those bills. We suspected the other two were coming. And that's part of the reason we use the notwithstanding clause there, is to protect the democratic will of the people.
Now, there's a lot to unpack there. And I'm gonna do my best. A lot of what Danny said was wrong. Having a judiciary that is arm's length is critically important in protecting the rights of people. Because here's the thing: somebody's asking me. I love it when people do this. Hey, Nate, would you ever consider running for office again? A, no, my family would kill me, and B, because I'm about to say something that, if I ever ran for office, I'm sure would be clipped at length. I mean, this is not the first time I've said something like that, but I'm going to say something a little controversial here. It shouldn't be, but it is. Danielle Smith said the will of the people. That's the thing. Here's the thing. The will of the people can be wrong. It can be. The will of the people can be wrong. A majority of people can be wrong about a thing. And when we're talking about human rights, there have to be guardrails in place, like an independent judiciary enforcing and supporting a charter of rights, to ensure that minority groups don't have their rights stripped or trampled by the majority, because the majority can be wrong. That's it. That's the whole ballgame. It's called tyranny of the masses, if we want to use the erudite term. But it's a real thing, and it's an established thing, and it's one of the reasons why a charter of rights and freedoms is so critically important. Because it's great if you're in the majority, but if we're going to say only the majority get to decide who gets rights and when, history teaches us very, very clearly where that ends up. Cough, Viktor Orban, cough. But the other piece is Danny's little thesis there, that democracy as a functioning institution can only work by the will of the people. Because again, the will of the people can be wrong. There's one other little piece that I want to tease out of there before we move on to the next phase of Danny's deconstructing the courts and the judiciary. And that is the importance of fertility, the importance of reproduction. There was a period where I was willing to extend a little bit of sympathy, grace, perhaps, for Danny's bias towards protecting fertility. I'm not speaking out of turn here. I've said it before on the show. It's not a secret. Danielle Smith can't have kids. So I can understand how somebody who's dealing with that could really, really value that. It does not excuse taking away other people's rights and inserting yourself into the doctor's offices across the province, to be absolutely clear. But I'm starting to think that maybe there's a few things that are happening that might just be a little bit more Machiavellian than that. But let's get back to the courts, because that first clip was from December 6th, right after Danny rolled out the notwithstanding clause on the anti-trans stuff. We've got Danny doing her end of year with everybody's favorite corporal punisher, Bruce McAllister.
You have used the notwithstanding clause a few times. You've taken a lot of flack for that. and you've also gotten a lot of support. I think about the teacher strike, some of the trans bills. Is it hard to use that legislation, or are you just so determined and so principled that we have to do this?
I never thought that. I remember people used to ask me about that when I first came in, and I couldn't really foresee of a circumstance where I would use the notwithstanding clause. But then I saw that the activists are going after the kids. And it's one thing for a person to make a decision about what their life choices are as an adult, whether it's surgery, whether it's medical intervention, whether it's changing their name. But when you're a 10-year-old child, you're too young to make a decision that might have a permanent impact on your ability to have kids. That's why we knew we had to stop the use of puberty blockers for minors 15 years of age and younger, stop surgeries until a person has become an adult and understands the consequences of what that means. It also meant that we had to make sure that parents were not going to be separated from what was going on with their kids. We'd heard stories of maybe well-meaning adults referring kids to gender clinics without the parents' knowledge, being called a different name without their parents' knowledge. And that's a devastating thing to do to a child, to separate them from their parents that way, and a devastating thing for parents too. And then the increasing stories that we heard about the danger of born male athletes competing in women and girls sports. We just knew that we might have been a little bit ahead of the conversation, but when the CAS report came out in the United Kingdom, when you see that the Nordic countries, Sweden, Finland, Norway, now New Zealand and the United States are all going down the same pathway as we are, saying, you know what, this medical intervention has not been tested. We don't know what the long-term consequences are. The watchful waiting has been the previous way that you deal with kids who have this kind of gender confusion, and we're going back to that because we just think it's going to preserve all the choices for kids. The reason we had to use a notwithstanding clause in that case was because the court struck down one of our laws. And when you see how long it takes for a final decision to be made in a court, it could take 4 or 5 years. And we just thought the harm that could potentially come to the number of kids in the meantime, we just thought, we know we're on side with where our public is, and that's the role of an elected official. You got to make decisions. The role of the court is to offer their interpretation of it, but too often I think the court has overstepped and not given the proper deference to the legislatures.
See, so what's happening there is Danny's saying that the courts can offer their opinion, but in her belief, the final arbiter of whether or not something is constitutional, whether or not something is legal, should not be the people who have spent their entire professional lives studying and practicing in that field. It should be the former talk show host. Nobody, please, ever trust me with that kind of power. But again, I just swerved myself with the whole tyranny of masses thing, so it's fine. But there's a couple things that I want to address in that clip. The first one is, I love Bruce's performative bullshit. So principled, fist in the air, so determined. It's like the preview for a new anime show. Danielle Smith, so principled, so determined. I love it. Puberty blockers don't cause sterility. Let's be clear. There were no surgeries that were being done for anyone under the age of 18 that caused sterility. They were already illegal in Canada. Look, we've got some fear-mongering going on. Not all of the countries that Danielle Smith has referenced have done the things that she's claiming they have done in the ways that they have done them. It's simply not true. She talks about preserving choices for kids. Not preserving the choices, you're taking them away from them and the parents who love them. Let's be clear about that. But we've got a whole bunch of, we're doing the fear, we're doing the things that should make people angry. And then we talk about how, gosh, those courts just overstep. This is a communications tactic. But we're not done denigrating the courts with our end of year with Spanky.
The recent ruling by the Supreme Court of Canada in a 5-4 decision that there should be no minimum sentence for anybody possessing child pornography is case in point.
It is. And the thing that is really underscores in that case is that it was a 5-4 decision. So when people say, oh, well, the court's decided, well, the court is often split
all 5
itself.
judges appointed by
Justin Trudeau. Precisely. One more reason why we may have to start looking at how we can have more role in appointing judges, particularly in our courts here.
Again, a lot to unpack there. And that clip is only like 20 seconds. But first things first, it's not what the ruling actually said. What the ruling actually said was there were foreseeable circumstances where, let's say, an 18-year-old was dating a 17-year-old and they shared some spicy texts. That 17-year-old would then have to have a minimum sentence, or sorry, the 18-year-old who's in that relationship with that person would then have to have a minimum sentence. It was a small part of the law that the courts said, you need to go back and fix this small part because we can see this happening and it's not great. Should people who are prolific offenders, criminals, absolutely, there should be minimum sentences. But if you have a law that is so blunt that it does not address the reality that in Alberta, people can get married under the age of 16 or under the age of 18, sorry. We have some logistical problems here. So that's what the courts were talking about in that ruling. The courts did not say, hey, everybody, it's a field day. They absolutely didn't. And to misrepresent that is, to me, a particularly craven form of politics. But the other two pieces that are interesting, Danny talks about, hey, you know what? The vote was 5-4. I don't know, Danny. Sounds like a majority. Sounds like a majority vote. Sounds like a group of 9 people exercised their democratic rights. So according to her own philosophy, if she was consistent with it, that should be enough for everybody to just go, whoa, whoa, hands off. There was a majority. What are you going to do? But that's not what she's doing here because that's not what's convenient. The other thing that's really important to highlight is what they said about judges at the end. I'm going to play the clip one more time. It's a short clip, but I want you to really focus on the last 5 seconds.
The recent ruling by the Supreme Court of Canada in a 5-4 decision that there should be no minimum sentence for anybody possessing child pornography. Yeah. Is case in point.
It is. And the thing that is so, really underscores in that case is that it was a 5-4 decision. So when people say, oh, well, the court's decided, well, the court is often split
all 5
itself.
Judges appointed by Justin Trudeau.
Precisely. One more reason why we may have to start looking at how we can have more role in appointing judges, particularly in our courts here.
One more reason why we may have to start looking at how we can have a more active role in appointing the judges. So to be clear, because Danny does not agree with that majority ruling, it was a close majority. I take nothing away from that. But because Danny doesn't agree with the misrepresented version of that majority ruling, not even the actual ruling, she believes that that's one more reason why she should have more say in appointing judges. But it didn't stop there.
Can we please write some provincial rules to tune these judges in and JPs that they can't be releasing people who are a risk to public safety?
I wish I could direct the judges, honestly, Chris. The judges get very, very prickly when you criticize them, but boy, the example that you just raised, they deserve the criticism. We have been pushing at the federal level to change the rules got changed by Justin Trudeau on sentencing and bail. And part of what the rules was you had to take into account whether somebody had a bad childhood and had some mitigating factors for why they became a criminal, and release them on that basis. And that doesn't make sense to me. It should be based on the seriousness of the crime. You can work on whatever issues they had in their childhood while they're incarcerated, rather than releasing them to go and cause this kind of havoc. So every single premier has put pressure on the federal government. They did one round of changes. It didn't work. The Carney government did another round of changes in the fall, so I hope that this one does work. I'm not a lawyer, and so I don't know whether we would be able to develop our own bail guidelines. The problem that we have is we only choose our judges at the lower court level. Court of Appeal and King's Bench are chosen by the federal government. And so we, in fact, I just wrote a letter to Mark Carney saying maybe we should look at a way, now that we've got some openings on King's Bench, for us to have a joint process to choose those judges, so that we start choosing judges in Alberta that reflect the values of how we want them to operate here. So I'll let you know how that goes. But that is a very complicated area of law, mostly in the federal realm. We have the power of administration of justice and policing, and we do work to exercise that to the full extent. But I don't think we have the authority to set our own bail conditions.
That's the clip that started off something of a firestorm in Alberta politics. Now, there's two things. Again, it's the ability to hold disparate ideas inside of one's head without experiencing any sort of cognitive dissonance that should be giving people cause for alarm. Because she says, I wish I could direct the judges. Now, that's not a thing that any leader of any functioning democracy should ever say out loud. It's just not. That's not something they should say. She said it. And she said it in the same breath almost as when she said, but I'm not a lawyer. Imagine someone saying, I wish I could tell the surgeons, the brain surgeons, how they should really be doing brain surgery. I have no medical background and know nothing of anatomy and physiology, but I just really wish that I could. When you say it like that, it sounds absolutely unhinged because it is absolutely unhinged. It's no different for Danielle Smith to say, hey, I'm not a lawyer. I don't know anything about the legal system, but boy, I wish I could direct the judges. And she did write that letter, although it did take both 2.5 weeks for her to finally release it to the public. And it might be because the way that she presented the situation in that exchange was like, hey, I want to see if we can work collaboratively, see if we can work things out with Mark Carney. But in the letter dated January 23rd, 2026, the day before that appearance on Your Province, Your Premier, Danielle Smith unequivocally said the government of Alberta expects that there will be meaningful engagement and collaboration before these judicial positions are filled. Alberta's government will not agree to provide the necessary funding to support any new judicial positions in the province until such engagement and collaboration are provided. So let's be real clear. She wanted to soft pedal the message and not acknowledge the fact that basically what she said is we have some vacancies in the courts. We have some positions that need to be filled in order for the legal system, which is by many accounts barely running, in order to keep it at the barely running state that it is. It is not running at the state that it should be. People are having to wait way too long. That's a well-established problem. But threatening to cut funding for judges, for the courts, that's not punishing Ottawa. That's punishing Albertans on a variety of different levels and ways. But that triggered a very rare response. Because on January 27th, 2026, all three Chief Justices for the three levels of courts in the province of Alberta issued, here's the thing. Judges don't speak publicly. They don't. It's not a thing that ever happens. And this is something that is well acknowledged by people who are familiar with how the justice system works. A judge will issue a ruling. You won't see them do the interview circuit after the fact saying, and this is why I did it, and let me put some spin on this for you folks. That's simply not something that judges do because they are arm's length. They are required to be objective. So for justices to issue a statement is a really big deal. For any justice to issue a public for immediate release statement is a huge big deal. A very, very rare thing. It is something that should have everybody going, wait, what is happening that this is considered necessary? And if you take a look at what the statement actually says, it is a remedial lesson on how democracy is actually supposed to work. Properly functioning democracy requires three separate branches of government that exercise their power and authority independently according to the Constitution. The executive branch makes policy and manages government operations. The legislative branch makes laws. In turn, the judicial branch interprets and applies those laws to disputes brought before the courts. If a party requests it, judges may be required to interpret and apply the Constitution and the Canadian Charter of Rights and Freedoms and make a ruling. The independence of each branch ensures there are checks and balances across the system. It is the foundation of a healthy democracy. Public trust and confidence in our institutions and all three branches of government depend on it. It is equally important that each branch respect and support the independence of the others. So let's be clear. We got the executive. That's the premier and executive council and all of that. Then you've got the legislative, and that's the legislative assembly with all of the MLAs. And then you've got the judiciary, which is the judges. And what the judges are saying is, in effect, stay in your own lane. Because when any one member of any of those groups starts to step on the others, that literally erodes the foundations on which any healthy democracy is built. And it's worth noting, currently, Danielle Smith is, in effect, the executive branch. She also leads the legislative branch. She's got two of the three. And so if she starts poking around at the third one, that should give everybody serious pause, and it should be creating a lot of concern, which it very clearly did, because these judges, and these are just like little judges. These are the chief justices for all three levels of court in Alberta issued this statement, this remedial civics lesson that apparently the premier of Alberta, certainly Spanky there, and the comms team, the support team, everybody else there needs to read. But it wasn't just the justices. The Canadian Bar Association also issued a letter on February 5th after Danielle Smith publicly released her letter, where they exercised and voiced very, very strong concern. There's two paragraphs in particular that I want to read. Alberta already has a strong voice in this process, with representatives on the 7-member committee appointed by CBA Alberta, the Chief Justice of Alberta, the Law Society of Alberta, and the province's Minister of Justice. All committee members are required to abide by a strict code of ethics that prohibits consideration of a candidate's political viewpoints. This composition ensures meaningful provincial input while preserving the judicial independence that is necessary, that is essential to the rule of law. So let's be very clear here. If somebody's going to get recommended to be a judge, it is a requirement that their political background does not play into whether or not they get to be recommended to be a judge or a higher court judge. You hear all of the people, Justin Trudeau appointed the judges. Yeah, because he was the prime minister at the time. He was actually prime minister for a few years. And if we were to say any of the judges that Justin Trudeau's government approved are somehow compromised, and therefore he shouldn't have approved any judges, the legal system would be in a far worse state than it currently is. So as much as Danny and Spanky want to misrepresent the process to suggest that Justin Trudeau handpicked the judges, it's simply not true. There is an administrative process that exists to safeguard against that sort of thing. There's another part of the letter that is really important. The suggestion, we are particularly concerned by your stated intention to withhold funding to support any new judicial positions in the province until your demands are met. While the federal government appoints and pays judges, provincial governments are responsible for the administration of courts, including court infrastructure and support services. Threatening to withhold this funding is not only unconstitutional, it also undermines the administrative autonomy of the courts, which is a core institutional safeguard of judicial independence. This tactic would also create real hardship for Albertans seeking to resolve their legal disputes before the courts and undermine public safety by exacerbating delays in criminal proceedings. And it's the truth. And it's important to realize that until somebody's been convicted, they're not guilty. So on one hand, We also just heard Danielle Smith saying, "Hey, we should be keeping people in jail. These bail recommendations, they're totally unacceptable." And on the other hand, she's saying, "Let's do something that is going to make sure that these people do not have timely access to a fair arm's length court process that will determine their guilt or their innocence." But that's still not all, because over 180 lawyers also penned an open letter where they talked about, among other things, the threats to defund the legal system. And let's just take that in again. This is the same Jolly Pirate Nixon group, not the lawyers, the UCP, that lit their hair on fire when people talked about defunding the police, which was a terrible slogan for what it was trying to accomplish. To be clear, also an American slogan, so it doesn't really apply quite so neatly in Canada. They're wanting the same group that were like, "Oh my gosh, these people are talking about Janice Irwin. She said defund. She was at a defund the police. She was adjacent to a defund the police thing, and we're just going to defund the courts because we're not getting our unconstitutional way." Fortunately, the federal government has basically said, "Hey, look, we have rules, we have processes."
I think more broadly first, ensuring that we have an independent judiciary is a hallmark of democracy and a key part of the rule of law. At risk of stating the obvious, it's essential that we have a judiciary who's able to make decisions without fear or favor amongst those who have the power to appoint or, in theory, remove a judge from the bench. When you start to look at how you can protect that independence, certainly ensuring that there's not political threats about the resources that are going to be made available to them to do their jobs as part of it. But another part is actually have integrity in the appointment process to begin with.
Which, by all accounts, there is. All of the people, the people who have the most to gain, all of the lawyers, the Bar Association. If there were problems, these would be the people that would know. And they're the ones that are saying there's a process, and the process matters because it creates guardrails that prevent political interference in that third part that is supposed to be independent and not touchable by the executive or the legislative branch. We've seen what's happened in the United States, where the courts have been politicized. And it's extremely important that we do not allow that to happen in Canada, and especially Alberta. Because if Danielle Smith gets her way, if she gets to take over the control of who gets appointed to the courts, that's deeply concerning for a lot of reasons. And I don't want to be a liar. And I really do believe that if Danielle Smith gets control of the courts, if she's able to direct judges, if she's able to choose the judges that she wants and she likes, despite the fact that she's not a lawyer, that should be terrifying to everybody. Because it's all good and well if it's your team that's winning in that moment, but as soon as another team steps up to the plate, those same circumstances of a corrupted system, those can cause real problems. And we're still not done with Danny undermining the legal system, because now we have to talk about the Alberta Civil Liberties Research Center. And this gets a little bit, we're going to go down a bit of a rabbit hole, so if you need to take a break, I mean, we're an hour in, probably got at least another half hour, 45 minutes left. So if you're watching this live, you can't really press pause, but if you're not, then press pause, because we got to talk about the Alberta Civil Liberties Research Center. And first, in order to talk about them, we got to talk about what they do. So the Alberta Civil Liberties Research Center, or ACLRC, from their own website, their mission is to promote respect for civil liberties and human rights in Alberta through research and education to contribute to a more just and inclusive community. They used the word inclusive. Their vision, a well-informed society empowered to advance civil liberties and human rights. The history of the ACLRC. The ACLRC was founded in 1982, shortly after the Canadian Charter of Rights and Freedoms became law by lawyer and activist Sheldon Schumer and Janet Keeping, an articling student who eventually became its first executive director. In its early days, the center assessed research questions about the charter and its impact on Albertans, but with time, its focus expanded to several human rights and civil liberties issues connected not only to the charter, but provincial and international laws. Some of these issues are racism and racial profiling, hate crimes, seniors' rights in Alberta, lesbian, gay, bisexual, trans, queer, intersex, asexual, and two-spirited, community rights in Alberta, privacy issues, freedom of expression, freedom of movement, policing in Alberta, and laws in a pandemic era. So the ACLRC does a lot of really important work in regards to educating people as to what their rights are, how their rights are supposed to be expressed as a function of the charter, and how that works with the laws that the province creates. And if we take a look at that list that I just read off and we compare it to the legislative agenda that Danielle Smith and the UCP have advanced so far, it becomes pretty clear how Danielle Smith and the UCP would maybe not so much want people being aware of the reality of all of those rights. And that maybe explains why Mickey Amory, who's not that guy in the picture, that guy in the picture is the head of the ACLRC. Mickey Amory just used powers from a recently passed law to veto pretty much the entire budget of the ACLRC. Now, how did this happen? Well, there's a few pieces to it. In order to really get a handle on the mechanisms that were used, back in April, the UCP passed Bill 39. And what Bill 39 did is it gave Mickey Amory the ability to approve or veto any funding commitment or grant agreement that exceeded $250,000, which it turns out is pretty much the entire operating budget for the ACLRC. Now, they did this by going through the Legal Professions Act and requiring that the Alberta Law Foundation, which gets its money from all the money that's put in trust. We did that on the last episode. Go back and listen to it. This part will make more sense. They did that by saying the Alberta Law Foundation is no longer by law allowed to give grants in the way that they have for literally decades. They now have to get Mickey Amory's approval. So Mickey Amory gets to decide who gets their grants and why. And this has caused a lot of problems. The biggest problem that is on the media landscape right now is the fact that Mickey Amory vetoed all of the funding for the ACLRC. In a letter released on February 3rd, 2026, the ACLRC articulated all of the problems. And what's really wild is they were actually approved for this money. In 2025, after a rigorous vetting process, the Alberta Law Foundation, which is the purse holders, approved the center's 2026 grant application for approximately $780,000 in accordance with the factors set out in the Legal Professions Act. However, the Alberta government recently passed legislation requiring any grant by ALF over $250,000 to be approved by the Minister of Justice. The minister decided to override the ALF's board decision and denied our grant application in its entirety. This is bonkers. This is absolutely bonkers. The fact that the Minister of Justice is targeting an organization whose primary job is to educate people how the legal system works, what their rights are, and shutting it down should be giving everybody, should be setting off alarm bells across the province. And it's important to realize that happened on, like I said, that letter was released on February 3rd. One might think, given all of this, Danny might pump the brakes on her attacks on the courts. Yesterday on Your Province, Your Premier, she doubled down.
Let's be very clear about what we've had happen in this country over the last couple of years, that we had a Trudeau government that completely upturned our sentencing guidelines. And as a result, we've had to see bill after bill after bill. We're now on our third bill at the federal level to try to give new guidance to the judges so that they don't do catch and release and get bad guys back out into the community. So we do have a role in to listen to people and to through the criminal code, proper channels, make sure that we're making those changes. And if you look at what's happening with Bill 14, it looks like it's been approved by both the opposition and it's being advanced by the federal government. And I hope that that will solve some of the problems that we're hearing. But it doesn't negate the fact that there are bilingual requirements that are unfair and stack the deck against Alberta judges. And we do need to be able to have a similar policy to Quebec.
Is withholding funding the best way to effect that change?
Well, you know, it's a negotiating position, of course. I mean, I'd rather get to a conclusion that is amenable to both of us and fair to both our provinces, as well as acknowledging that there's a federal role to play, of course. But I think we want some parity. So we've started the conversation, and hopefully we'll have some success on it.
Will you have any kind of oversight to ensure that judicial appointments remain impartial?
Well, not me. I mean, this is all within the realm of the Justice Minister, who is our Attorney General, and he's the one who is making the ask, and I trust his judgment. I think that he has already demonstrated, because he does KC appointments. There's an established process for that. We do have one member, as I understand it, on the committee, although it's got 3 federal members. It's just asking for some balance, and I think we'd get a more balanced approach when it comes to those appointments. But I wouldn't be involved in that. It would be led by my Attorney General.
Which brings us to this week's episode of Danielle Smith Lies. And I'm going to prove it in like 5 seconds because it's super, super easy. Mickey Amery's the one. He's the one who's making the ask. Danielle Smith wouldn't have any hand in this. It's all Mickey. It's not like Danielle Smith's directing the thing. Let's go back to that letter that was sent to the Right Honorable Mark Carney. Who was it signed by again? Danielle Smith, Honorable Danielle Smith, Premier of Alberta. She CC'd Mickey Amery, and she CC'd Honorable Sean Fraser, Minister of Justice and Attorney General of Canada. But the arguments came from Danny. So it's ludicrous for Danielle Smith to say on her radio show, whoa, I wouldn't be directing any of this. It's not like I just did, when she literally just did. Mickey Amery is Justice Minister because Danielle Smith allows him to be. And it's become abundantly clear that Danielle Smith's agenda is Danielle Smith's agenda. If Mickey Amery was to do something that Danielle Smith didn't like, or didn't do something that Danielle Smith did like, he could very, very easily be removed from his position with a stroke of the pen. So for Danielle Smith to say, whoa, it's all independent with Mickey Amery, is, first of all, that's a stretch you're asking people to believe, especially after you just lied about who it was who made the overture to the federal government and the threats about withholding funding. Because, again, it's not Mickey Amery's name on the bottom of that letter. It's Danielle Smith.